Thanks to those of you who haven't spoken with me before. I'm Youssef Raab with the American Foundation for Equal Rights, the sole sponsor of the Perry v. Schwarzenegger case. And, of course, we're on the web at equalrightsfoundation.org. Soon I'll turn it over to Theodore J. Boutros, one of our lead attorneys on the case and an eminent and distinguished practitioner of appellate law with a long history. We're going to be quick here because we are up against a tight timeline. As you know, last night, our legal team, headed by Theodore Olson and David Boies of Gibson, Dunn & Crutcher and Boies, Schiller & Flexner, filed our brief with the Ninth Circuit Court of Appeals, and they demonstrated, as they did at trial, that Proposition 8 is clearly and unequivocally unconstitutional. This litigation is, of course, complex, but when you translate the legalese, the case against Proposition 8 is simple. This is a case about whether all Americans shall indeed be protected by the Constitution's mandate that all Americans should be treated equally under the law and by our government. This is a case about whether the government can continue applying different and unequal laws to Americans like plaintiffs Chris Perry, Sandy Steer, Paul Katami, and Jeff Zimmerlo. With that, I'll turn it over to Ted. And again, we do have a tight timeline, but we'll try to get through all of your questions. And if not, of course, just give me a call. Ted?
Thank you, Youssef. And I'll make my opening remarks brief, since our brief is pretty lengthy and you all have it. And we really tried to lay out the core themes that we began with in this case and that we put to Judge Walker during the trial, that first of all, the Supreme Court's decisions on marriage, at least 14 of them have talked about how marriage is a fundamental right of all persons, and it's a fundamental relationship, the most important relationship in life. And that line of cases includes Loving versus Virginia. The other lines of cases include the Lawrence decision on due process and the freedom and liberty interests of gay men and lesbians, and then Romer, which is the equal protection companion case in a sense to Lawrence. And we think that when you put those cases together with the marriage cases, the law is overwhelmingly on our side, and Chief Judge Walker got it exactly right. On top of that, we have the factual record, and for those who've been following this case all along and were there at the trial, you saw that the proponents didn't have any evidence. Their arguments got narrower and narrower once their lawyer admitted he did not know what harm would occur as a result of same-sex couples getting married. They had to change their arguments and finesse their arguments to try to explain that statement. And I think that drove many of their arguments in the closing arguments and in their brief. Our record is overwhelming in terms of the experts, the factual presentation by our plaintiffs who told their powerful story. And on an appeal, to have that kind of factual record to work with and to have really no factual record on the other side responding to it, I think gave us the opportunity to put it all together into a brief that powerfully lays forth both the legal arguments with the factual case on these important issues. The other thing that we wanted to make clear in this brief is that the proponents in their brief really distorted what happened at the trial, misstated what happened during the proceedings, and have really, I think their brief had some extraordinary attacks on the process that were completely unjustified and really simply, I think, the best they could do since they had no strong legal arguments and no factual record whatsoever. And to me, that was one of the most striking things about their brief, that they had to resort to sort of ad hominem misstatements about the proceedings. So we feel very good about where we stand, and I'm happy to answer any questions that you might have.
The floor is now open for questions. If you do have a question, please press the number 7 or the letter Q on your telephone keypad. Questions will be taken in the order they were received. If at any point your question has been answered, you may press 7 or Q again to disable your request. If you are using a speakerphone, we ask that while posing your question, you pick up your handset to provide favorable sound quality. Our first question comes from Karen Ocom of Frontiers NLA. Karen, please state your question.
Thank you, Ted and Youssef. I have actually more of a political question. As you may know, Equality California had a conference call with UC Irvine Law School Dean Erwin Chemerinsky a little while last week, and he said he was very concerned about the possibility in the future that if Steve Cooley, he didn't say the name, but if Steve Cooley was elected Attorney General or Meg Whitman was elected governor, that they could in some way influence or try to intercede as a government defendant. And even if they were unsuccessful in that, they could file a friend of the court brief, which would probably influence the ultimate ruling. So I'm wondering if you could speak to that, please, Ted.
Sure, Karen. Thank you. First of all, that does not concern us whatsoever for several reasons. First, I'm not sure if procedurally they could do it, but we're not afraid of anyone's arguments or anyone filing briefs and getting their views across in this case, because we think we're right on the law and we're right on the facts. And so we're we think that if there are new attorney general and a new governor and they express their views, we'll address it and deal with it. But that doesn't concern us at all.
Could I ask a follow-up?
Sure.
What about? Do you have an opinion about the filing? Oh my heavens! I'm sorry. Riverside. Trying to appeal and get in.
Oh, Imperial County.
I'm sorry, Imperial County.
Yes, we filed a brief, urging the court to affirm Judge Walker's ruling that intervention should not be allowed. We think Judge Walker was right, but again, there are these procedural issues in the case. As we've said all along, we think we are right on the merits, and we welcome. We've laid out our arguments on these jurisdictional issues, which have to be addressed by the courts, but we feel strongly that the court should affirm on the merits as well.
Okay,
so we did file a brief responding to Imperial County late last night as well.
Right, thank you.
Sure.
The next question comes from Julia Cheever of A City News Service. Julia, please state your question.
Hello. My question is about the standing issue, and I have to say I haven't read your brief yet on that particular subject, but how important do you think that is, and how much emphasis have you given that in your brief? It seems counterintuitive that nobody should be able to appeal this lower court ruling.
It is an issue we addressed because the Ninth Circuit requested briefing on it, and it's a jurisdictional issue. So it's the kind of issue that even if the parties don't want to address it, the courts have a duty to look at it and make sure they have jurisdiction, that someone has standing to pursue the appeal. So we do address it. The law, and I think we've laid out our rationale why the proponents don't have standing, but it's as you may notice, it's not a large part of our brief, in part because we brought this case because we want the courts to rule that gay men and lesbians have the same rights as everyone else under the Constitution. And so we welcome briefing on the merits. We welcome a decision on the merits. The Ninth Circuit's going to have to grapple with this standing issue and come to some resolution. We've laid out the case law as the best we can discern it. But it's an area where the Supreme Court has suggested there's no standing, but both sides have made their arguments as to what should happen in this case, and we're ready no matter what happens.
Okay, thank you.
Sure.
The next question comes from Devin Dwyer of ABC News. Devin, please state your question.
Hi, Ted. Thanks for taking my question. We're very interested in the fact that the state is not defending the law. The governor and the attorney general have not. And at this stage, I guess I have two questions for you. How much has that helped you thus far in the case, and would you expect it to help your arguments going forward? And two, could you talk a little bit about what precedent there may or may not be for that point that the state is not defending this law? And I don't want to veer too much off into the don't ask, don't tell case, but obviously similar gay rights issues there, and the administration has said they're obligated to defend that part of federal law. So I'm wondering if you could maybe discuss that.
Absolutely. First, it helped us not in terms of the having a worthy opponent that the governor and the attorney general did not defend or put on a case at trial, because the proponents, despite their complaints about the system, put on an extraordinarily vigorous case. They did the best they could with a very weak hand, and they litigated extremely aggressively on all fronts and made their tactical decisions. So it didn't really help us on that front, but it helped us, I think, enormously that the Attorney General of the state declared and admitted that this state law is unconstitutional, and that's something that is, I think, powerful when the state's chief law enforcement officer says that law is unconstitutional. So that, I think, helped us. With respect to the decision by the state officials not to defend, it happens every once in a while, and it has happened in California. There's a case called Reitman, which went to the U.S. Supreme Court, where the California Attorney General viewed a law that discriminated based on race in terms of housing as unconstitutional and declined to defend that law. And it was actually a ballot initiative case. So it does happen, and it happens fairly frequently, not fairly frequently, but it happens every once in a while at the federal level as well, where the Solicitor General on behalf of the United States will confess error or decline to defend a law. And I don't know what is going through the administration's thought process on Don't Ask, Don't Tell, because it would be appropriate for them to say the law has been deemed unconstitutional. We are not going to seek further review of that, and I think that the Attorney General and the Governor made the right decision here by sticking to their principles and respecting Chief Judge Walker's decision.
Yeah, Ted, if I may interject, this is Yusef. Just on that token, the situation we have here in California is with a law that is rather starkly unconstitutional. And so it is entirely understandable that the Attorney General and the Governor chose not to defend. There's really, in our opinion, very little wiggle room here, considering the overwhelming amount of evidence against Proposition 8 and, the fact that it violates none other than the due process and equal protection clauses, amongst others, really makes it not just a principled stand, but one grounded in their legal duty as well.
And I would just add, two of the cases that are discussed in the parties' briefs on the standing issue, the Arizonans for official English and the Diamond v. Charles case, involved situations where state governments determined not to defend their laws. And so this does happen, and I think the officials are to be commended for looking at it, making a call as to what they would do based on what the judge ruled.
Thank you both very much.
You bet.
The next question comes from Lisa Leff of the Associated Press. Lisa, please state your question.
Good morning, everybody. Ted, I wanted to ask you if you could elaborate a little bit more on the time you all spent in the brief advising the Ninth Circuit to give great deference to the trial record. As you noted in your opening comments, the lopsided nature of the trial testimony. It's also the Protect Marriage folks who have also said, well, in their argument have tried to convince the Ninth Circuit that it could sort of, start over, that it doesn't really have to give a lot of deference. And I've heard from, sort of people not directly involved with the case that, it's not like that's a slam dunk argument, but that it wouldn't be unheard of for an appeals court to say, we'll, pick and choose. We'll pick and choose the facts that we consider and kind of, that it does have the authority to sort of start over a little bit. So you can just talk a little bit about what your all's thinking is on those lines?
Absolutely, Lisa. Good to hear from you.
Good to hear from you too.
The way we look at it is, first of all, the issues, the factual issues that were part of the trial that related to the meaning of marriage and the history of marriage, the effect on our plaintiffs of this discriminatory law, the campaign's messaging, which we put factual evidence in, the issues of parenting and stigma and discrimination, all those issues have been issues that the proponents have argued about, and they had their expert, Mr. Blankenhorn, before he was brought into court, and other people debating these points. And Chief Judge Walker, I think, correctly determined, look, there are arguments on both sides. Let's put them to the test of the adversarial system, including cross-examination of witnesses. And I think in a case like this, that the Ninth Circuit has before it a factual record where these facts were tested. It's not just spin, it's not just argument, it's not just rhetoric. And I think that under the law, those facts are entitled to deference. There are some areas, as we point out in the brief, where courts do say some facts fall into this other area where the Ninth Circuit can look at the issue itself and make a decision. But we're not afraid of that either, because on those issues, our experts gave testimony based on scientifically sound studies, based on reliable methodologies, based on the kind of evidence the Ninth Circuit and other courts are used to looking at. And so I think if the Ninth Circuit looks de novo at those issues based on the record we put before it, it will come to the same conclusion as Chief Judge Walker, because the evidence is so lopsided and the studies are so lopsided. If the proponents had evidence on these crucial issues, they would have put it in the record. They would have called experts to the stand. They didn't do it because they couldn't find anyone who could withstand scrutiny, who had conducted reliable studies. So I think the findings are entitled to deference, but we think that the record is so powerful that any court looking at it straight up, de novo, on its own, would find that the same thing Chief Judge Walker found, that the proponents put on no case, and the materials they're now relying on, that the secondhand sources that they claim proves these points, do not prove these points, and that we're right on the facts. So I think it's an interesting issue. I think we're correct in the way we've analyzed it and laid it out in our brief, and we feel very good about where we are, because we think the record is both in the trial and in the literature is powerfully on our side.
Okay. Thank you.
Thank you.
The next question comes from Michael Linderberger of Time. Michael, please state your question.
Thank you, and hello, Ted. I just wanted to get a sense of if they agree with you and Chief Judge Walker that they don't have standing, if the Ninth Circuit agrees, are there questions of legitimacy that's been raised? I mean, just sort of how valid will a ruling in your favor be if it never gets to get appealed? And the same question, of course, as alluded earlier, is sort of being asked about the don't ask, don't tell. Are you concerned about that?
Well, I think it will. We would like to have the courts rule on the merits in our favor, because, as I think you're implying, that would be the type of ruling that would have the maximum impact, and it would be an appellate ruling affirming what Chief Judge Walker did. And I think if we prevail on standing, I think that that ruling and Chief Judge Walker's ruling would stand, and it would be the law in the Ninth Circuit, and it would be the law in our Proposition A would be struck down, and I think that would be important as well. I think our preference is to get a ruling on the merits, because it will have a broader effect. It will stand. It will be an affirmed ruling on the merits. And at the same time, if we are able to maintain a ruling that Proposition 8 is unconstitutional and marriages can occur, that would be a significant victory too. And I think Chief Judge Walker's ruling will stand the test of time, and people will look back on that ruling, no matter how we win on appeal, and say this is a great ruling, it's a historic ruling, and it's a correct ruling.
Thank you. And I had one other quick follow-up question. You mentioned earlier, or you mentioned in your brief, Lawrence v. Texas, and I remember when that was decided, Justice Scalia really went to great pains to point out what kinds of decisions that case would open up in the future. One of the things he talked about was gay marriage. How important is Lawrence v. Texas in these subsequent cases, including your own? Is it proven to be the milestone that people thought it might be at the time?
I think it's very, very important, for two reasons at least. One is the reason you're suggesting. Justice Scalia said, if this ruling is correct, if the majority's ruling is correct, then that means there's no basis to restrict the liberty interest of gay men and lesbians in terms of marriage. And so he, Justice Scalia was following the legal principles in the majority to their logical conclusion. And that brings me to the second reason Lawrence is so important, because the court talked about the autonomy and freedom that relates to the relationships between people and the liberty interest involved in that. And the court, in the majority, while it didn't address the issue and rule on the issue of marriage, talked about the fact that that this liberty interest in all things related to the marriage relationship were, I guess the way the court put it, constitutional protections for personal decisions relating to marriage fall within the due process liberty clause. And so that, I think, is extremely important. And the type of scrutiny that the court gave to the laws in Lawrence, I think, was much more rigorous than what the kind that the proponents are arguing should apply in our case. So I think it's a very important decision, and that its rationale strongly supports our position in this case. Thank you.
The next question comes from Maura Dolan of the LA Times. Maura, please state your question.
Hi, Ted. I've got a question about standing in state law. As you pointed out in the brief, the California Supreme Court in the marriage rulings did not give the Prop 22 people standing, but then they did give the ballot proponents of Proposition 8 standing in the Prop 8 case. Can you kind of refresh my memory, how they in one situation said no standing, and the other they allowed them to argue the case?
Yeah, I think in the first, in the marriage cases, it is much more comparable to our situation, because we have people who aren't affected by the law who aren't injured in any way, and by their own admission say they don't know what the harm would be, at least by their lawyer's own admission. In the Prop 8 case, I think it was different in the sense that you had the challenge to Proposition 8 was brought by people who did have standing, and therefore, and I may want to go back and just double check this, but because the people who were challenging Proposition 8 had standing, then it was very much like what we had in the trial court in our case, that the proponents were entitled to come in and defend Proposition 8 the way they did here. So it was when they weren't pursuing the appeal, that's the difference. I'm not being really clear, but I think that's the distinguishing factor. In the marriage cases, they were trying to pursue arguments, and in the Proposition 8 case, the Strauss case, there they were defending it when people who had standing could bring the case. But let me look at that, and I can clarify that if that's too vague an answer for you.
Okay, that is a little confusing.
Okay.
Okay, thanks.
You bet.
The next question comes from Lisa Keene of Team News Service. Lisa, please state your question.
Ted, if the Ninth Circuit says proponents don't have standing, won't they then decline to rule on the constitutional issues?
That's one option. They could say we hereby find no standing and we're not going to rule on the merits. There's also different judges could come to different conclusions. One could say I don't think they're standing. Two could say we do think they're standing and we affirm on the merits. And as we go forward, it could break down on different grounds. A panel could also say we don't think they're standing, but the Supreme Court's cases, there is a debate here, and we're going to go to the next stage because, assuming there is standing, we're going to rule, and courts often do that, then rule on the merits in the alternative. And so I think that there are a number of options and a number of ways the courts could address the appeal.
Okay, so in anticipation that proponents would appeal the standing issue to the Supreme Court, they might go ahead and rule on the merits. So
exactly.
The Supreme Court would. I got you. Thank you very much.
Yep.
The next question comes from Lisa Leff of the Associated Press. Lisa, please state your question.
Hi, sorry for chiming in again. I forgot what my follow-up question was. Ted, how does the City of San Francisco's brief complement the brief that you have filed? I read something yesterday that was suggesting that, by focusing to such a great extent on California law, that it gives the Ninth Circuit the ability to tailor a more narrow ruling.
I think their brief complements our brief quite nicely. We make the same point in our brief, but with so many different arguments, we did not develop it in as much detail as the proponents, as the city has in their brief, and that is just focusing in on California and on Proposition 8, on the uniqueness of Proposition 8, stripping away the rights of other people, of one group of people, for the sole purpose of taking away their rights in this context of a regime where we have all these laws that are on the books that really refute the very arguments the proponents are making in support of Proposition 8. And so I think it's another, yet another ground for striking down Proposition 8, and I think it complements the fact that we have due process, we have equal protection, we have broad arguments, we have some narrower arguments, and we want to collectively to put the full menu of arguments out there in the most persuasive way possible. So I think that their brief ended up complementing our brief quite nicely.
Is that an accurate, what I was saying when I heard it being analyzed as a way to give the Ninth Circuit more narrow grounds, is that an accurate analysis, or is it more like they're sort of amplifying the Romer argument?
I think, I view it as amplifying the Romer argument, and we make the Romer argument, and I think you've probably heard me talk about the parallels our team has always seen between our case and Romer, and that's one way to resolve this case, and it would be a powerful, strong ruling that would be extraordinarily helpful in across the country if the court took Romer and then applied the Romer type analysis the way Chief Judge Walker did, but then zeroed in on the particulars of Proposition 8, and that's certainly one very powerful argument for striking down Proposition 8. That's how I look at it. And different courts take a different approach to different issues, and that's certainly one I think great argument that we've been included in the case from day one.
Yep. Thank you.
Sure.
It appears there are no further questions.
All right. Well, thanks, everybody. And you know how to reach us if you need anything else.
Thank you, everyone.
Thank you. This does conclude today's teleconference. You may disconnect your lines at this time.